And welcome everyone. This session is Rest in Peace, Essential Elements of Family Provision Settlement Deeds. So in this session, we'll look at resolution of family provision claims and the subsequent documents recording the agreement. In particular, where a deed between the parties is required, we'll have a look at what's necessary for the drafting of the deed and the relevant matters to consider. We'll also look at the involvement of the court in the resolution of proceedings, particularly where court orders are required, and where that is the case, what to do to satisfy the court in terms of its requirements for the making of the orders, and where disagreements break out after resolution, what can be done in those circumstances. In my experience with family provision proceedings, the vast majority of matters settle, whether that's at a formal mediation or shortly after, or even at the steps of the court. In New South Wales, at least, mediation is compulsory, and so we see a lot of matters at mediation. All going well, matters will settle at mediation, but there are also opportunities to settle afterwards as well. So an important matter to consider in negotiations and at a mediation is, have you reached a binding agreement? At mediation, it's quite common for parties to have agreed terms and enter into heads of agreement with the intention of having a deed prepared and entered into at a later time. The question that can often arise is whether the heads of agreement are binding, and the court has been asked to consider that question on a number of occasions. One of the most referred cases is Masters and Cameron. In that case, the High Court dealt with a situation where the parties had reached an agreement in relation to the sale of farming property, and it was in the form of a memorandum which stated, "This agreement is made subject to the preparation of a formal contract of sale, which will be acceptable to my solicitors on the above terms and conditions." A deposit was paid in conjunction with the agreement, but prior to the parties signing a formal contract of sale, the purchaser decided not to go ahead with the purchase of the property, and the vendor commenced proceedings to enforce the agreement. The High Court held that where parties enter an agreement while also agreeing to draw up a more formal contract, the case may fall into one of three categories. The first one is where the parties are bound immediately, but there's a desire for more formal documentation to be entered into. And so that's an example where there's a heads of agreement that's signed, but the parties agree that there's going to be a formal deed signed after the mediation. The second one is where the parties agree to be bound immediately, but it's subject to operation of a particular clause or upon the execution of a formal document. So, for instance, that could be where an agreement is reached, but it's subject to one of the parties being able to have finance approved in order to satisfy the terms. And the third category is where the parties postpone a binding agreement until there's a formal contract entered into. The Australian courts have also indicated that there's a fourth category as well, where the parties agree to be bound immediately by agreed terms while expecting a formal contract to be made containing additional terms in substitution for the first agreement. In the case of Bobby Demetsky, the New South Wales Supreme Court was asked to determine whether heads of agreement which contemplated a subsequent deed of mortgage and release and the provision of security in the form of a mortgage was binding upon the parties. Justice Sakar determined that where there is a heads of agreement, what needs to be looked at is whether the parties intended to be bound by the agreement, and the court will look at the language that's contained in the heads of agreement to give an indication of what the intention was. He said that the heads of agreement have to be read in light of the surrounding circumstances, and if the terms of the heads of agreement indicate that the parties agree to be bound immediately, then effect must be given to that. And lastly, that in determining the intention, post-contractual conduct is admissible to determine whether a contract exists between the parties. So in this case, the plaintiff asserted that it was a Category 1 Masters and Cameron agreement. One of the defendants denied that the head of agreement was binding and argued that it constituted no more than an agreement to agree, falling within the third category. Justice Sakar applied the principles that he set out and determined that looking objectively, the heads of agreement was a binding agreement to subject to two outstanding events to occur. One was the deed of release to be entered into, and the second was the provision of a mortgage. So his determination was that it was a heads of agreement that would fall within the first category of Masters and Cameron. So at a mediation, the safest outcome is to have all of the documents that are needed prepared at the time of the mediation, because if you are leaving a deed or another document to be prepared after the mediation, that can give rise to disagreements about the terms of that document or disagreement about whether there's really a binding agreement entered into at the mediation. So where there are arguments about binding agreements reached at mediation, it gives rise to questions about the extent to which disclosure of what occurred at a mediation can be made. The first place to look when considering that is Section 131 of the Evidence Acts, and that says that evidence is not to be adduced of a communication that's made in connection with an attempt to negotiate a settlement, including communication with third parties. It's important to bear in mind that Section 131 only relates to civil matters and not criminal. There are a number of exceptions which apply to Section 131. The first is in proceedings in which it's sought to adduce evidence to enforce the agreement between the parties, or of a proceeding which the making of such an agreement is in issue. Also important to bear in mind is that Section 131 doesn't apply to court-ordered mediations. So communications made in a mediation that's ordered by the court are often privileged under the legislation of that jurisdiction, but have been found to be excluded from the application of Section 131. For example, the case of Rajewski and Tectron Corporation, it's a New South Wales decision of Justice Palmer. He held that Section 131 isn't intended to apply to the special process of settlement negotiation provided by a mediation ordered by the court under the provisions of what was Part 7B of the Supreme Court Act. That, of course, has been repealed, and now it is Section 29 of the Civil Procedure Act. And in New South Wales, that states that the court may make orders to give effect to any agreement arising out of a mediation session, and any party can call evidence from the mediator or any person involved in the mediation as to the fact that an agreement or an arrangement has been reached, and also as to the substance of the agreement or arrangement. Further, it says that the part doesn't affect the enforceability of any agreement or arrangement that's made, whether or not arising out of the mediation session. There are similar legislation in other jurisdiction. For instance, the Civil Procedure Act in Queensland, Part 6 deals with the admissibility of the ADR process. So, for instance, Section 50 says that a party can apply to the court for an order giving effect to the agreement reached. Section 53, evidence of anything that's said or done or admissible is admissible at the trial only if the parties consent. In the ACT, the relevant legislation is Section 52B of the Court Procedures Act, and in Tasmania, it has adopted Section 131 of the Evidence Act, and in Western Australia, there is confidentiality provisions as well. Usually at a mediation, there's a mediation agreement, and that usually provides that the information conveyed during the mediation is not to be disclosed unless compelled by law or without the prior consent of the parties. There's often a separate confidentiality agreement that's entered into by people who attend the mediation who are not parties. And for the most part, mediation agreements specify that in order for there to be a binding agreement, the parties will need to have something in writing and signed by the parties at the conclusion of the mediation. So are orders of the court needed? You've got a deed, which is binding upon the parties. Do you also need court orders? The two main reasons why you would need court orders is, firstly, if there was property that is being transferred to a beneficiary, for that property to be not liable for stamp duty, there would need to be an order of the court. And the second usual reason is that if the defendant or the beneficiary is giving up an interest in favour of the plaintiff and that person's on Centrelink, there will usually need to be an order reducing that person's interest. Otherwise, Centrelink may consider that to have been a gift and the person will be deemed to have had that benefit, and it could affect the benefits that they're receiving. So in New South Wales, Section 63 of the Duties Act indicates that there will be nominal duty if there's property transferred to a beneficiary by will or intestacy. Where there's an order of the court, Section 72 of the Succession Act states that family provision orders have the effect of a codicil, and there's a duty ruling which states that if there's a transfer pursuant to a family provision order, that will have the same effect as if it was property transferred by will, and nominal duty will be paid. Further, in New South Wales, there is Section 66(3), which is the ancillary and additional orders that need to be made. And Section 66(3) states that if there's a family provision order that deals with transfer of property from notional estate of a deceased person, that is also covered by the nominal duty provision. So if a beneficiary is receiving property by way of transfer out of the estate or notional estate where there's an order made, the result should be that that is not liable for ad valorem stamp duty. In other jurisdictions, in Queensland, there is a public ruling stating that there's exemptions that apply to appropriations where there's only a slight variation, and the Commissioner has to be satisfied that the intention was followed as closely as possible. So where a beneficiary decides to take property in lieu of their, or as part of their entitlement, where that property is appropriated in Queensland, that should have mean that the property is not liable for stamp duty, but only up to the value of the beneficiary's entitlement under the will. Okay, so going back to the settlement structure and the structuring the settlement, I guess the options are that you can do that by way of deed or by way of agreement. The impetus for having a deed might be where the estate requires releases from the beneficiaries, or where it has to record an agreement that can't be just dealt with by way of the orders. So a deed is a enforceable, it is enforceable without the need to exchange counterparts. So the requirement is merely for consideration. So there's no need for consideration to pass between the parties. So if you want to have a binding agreement where there's no consideration, but there are releases or other obligations upon a party, then a deed is the appropriate vehicle. And where that's signed, sealed and delivered and executed as a deed, those considerations will be dealt with. Also important in a deed, if there's a loan or other sort of accommodation, then there'll be a longer limitation period. The normal limitation period for a cause of action is 6 years, but where there's a cause of action arising out of a deed, then the limitation in New South Wales is 12 years. In South Australia and Victoria, the limitation period with a deed is 15 years. In contrast, if there's an agreement between the parties, it doesn't need to be in writing. It's safer if it is, so that the terms are not subject of a dispute. And an agreement has to meet all of the necessary elements to create a binding agreement, so offer an acceptance and consideration. When drafting a deed, sometimes it's useful to have schedules or attachments to it. For instance, where the transaction is complex and you need to refer to various sub-agreements or terms, there may be benefit where the transaction entails various smaller transactions, and a separate schedule may contain a separation of facts and obligations. Where schedules and attachments are used, it should be clearly specified whether it's intended that they form an integral part of the main agreement. And in New South Wales, at least, it's not unusual for the orders of the court to note the terms of an agreement between the parties where there's the settlement of a family provision claim. In terms of drafting tips, it's important to use plain language, which is easily understandable and interpreted, and short sentences assist with the use of plain language and easily comprehended terms. If the deed relates to legislation or case law, it's a good idea to quote directly from the legislation, so there can't be any ambiguity about what is being referred to. Where there are frequently defined, frequently used terms. It's handy to have those defined so that you don't have to use them throughout the document. Subheadings, indexes, and numbered pages are useful just from a structural point of view. Often we would use precedents for the preparation of a deed, but just bear in mind that all factual situations aren't interchangeable, and it's important to adapt precedents to apply to the particular case that you're dealing with. And also always, of course, check your work, have a colleague check it, or a barrister, just to confirm that there aren't any obvious errors or things that need to be changed. Deeds will often contain recitals, and the purpose of those recitals are to provide background and context of the situation. So where there's a deceased estate and there's a family provision claim, then it's useful just to set out when the deceased died, whether there was a will and whether probate's being granted, who are the beneficiaries and who are the executors, defining the nature of the dispute, the fact that there are family provision proceedings on foot, and if that's the case, to refer to the pleadings and the proceedings numbers. It's important to set out the position taken by the different parties, where the parties do take different positions. It can be stated that party X asserts A, B, and C, and that party Y denies A, B, and C and asserts D, E, and F instead. In terms of the intentions of the parties, recitals can be a convenient way of recording those intentions. It's important to avoid admissions in the recitals, and perhaps the parties would require that settlement is being undertaken without the admission of liability. The recitals aren't an operative part of the deed. It's really just to set out the background and provide some context to the disagreement and context to the resolution. In the case of the administrators of South Head and District Synagogue, there was a dispute about the effectiveness or whether recitals contained an obligation or whether it was just setting out background. The case determined that part of the recitals of the contract weren't intended to give rise to obligations. It involved a contract between a rabbi and a company controlled by the congregation that employed him. The issue was whether the principle of Orthodox Jewish law providing the rabbi with life tenure was expressly incorporated as a term into the agreement or was just part of the background. At first instance, the recital stated the relationship between the rabbi and the congregation shall be defined in accordance with halacha, being the Jewish Orthodox law. At first instance, it was found that the clause was intended to be legally binding and that the rabbi had life tenure. That was appealed, and on appeal it was found that it was in the nature of a recital and that it was not, as held by the trial judge, inconceivable for the term not to be intended to give rise to legal obligations. In family provision deeds, it's often necessary to describe relevant property and assets. With real estate, it's important to give the address and the title deeds so that the property that's intended to be addressed is clearly identified and there can't be any dispute about which property it is. In terms of shares, it's important to keep the SRN or HIN details confidential because that's really the security for the ability to transfer the shares. Shares can be referred to in terms of parcels and the number of shares held. In terms of bank accounts, it's important to have the name on the account and identify the branch of the bank with BSB and account details. If there are a number of properties, it's important to define the property. So, for instance, define it as the Millthorpe property as opposed to another property as the Orange property. With the agreement, if there's residue, it's important to indicate who's entitled to the residue and what's to happen to the residue. Where there's a specific gift, ordinarily the beneficiary will need to bear the cost of the transfer of the specific gift, and also where the specific gift is, for instance, an asset earning asset, then the beneficiary will be entitled to the income from that asset from the date of death, and also will be responsible for the payment of the outgoings of the property, and an accounting can be prepared to determine what the net figure is, whether there's income over outgoings or whether there's money that the beneficiary has to pay into the estate to cover the outgoings. If there's any change to the usual position of the gift of a specific asset, then that needs to be clearly stated in the deed so that there's not an argument afterwards about who's paying for the costs of the transfer of the property or who is entitled to the income. Often there are, in family provision cases, there are a number of beneficiaries whose interests may be affected by the agreement. The parties to the agreement should be fully identified and named, and similarly with the company, the registered address of the company should be included and the ACN identifying the company. Where there are a number of parties to the agreement, and particularly where there's a beneficiary who doesn't consent, often the question will arise, what is to be done where a beneficiary doesn't consent? It's an important question for the executor to consider, because if the executor compromises a beneficiary's claim, he or she may be at risk of personal liability in respect of a later claim by that beneficiary, where the beneficiary says, well, I was under the will, I get X amount, you've given me less than that, and I'm claiming personally against you for the balance. So where a beneficiary's entitlement is compromised, it's important to either get their consent. Where consent isn't given, the executor can consider obtaining judicial advice as to whether they're justified in resolving proceedings where a particular beneficiary's interest is compromised and consent isn't given. In the case of Sacalorio, that was a matter where a beneficiary's interests were compromised. They didn't consent, and the court declined to make orders in accordance with the agreement. That was a matter where there were stepchildren of the deceased who brought the claim. Their children were beneficiaries under the will. The given to the claimants was borne by charities and by their children. However, the children didn't agree and opposed the making of orders. The judge declined to make orders to give effect to the agreement, and said that it wasn't enough that the executors relied on the relationship between the claimants and the beneficiaries, that the executors had a duty to inquire whether the beneficiaries consented, what their financial position was to determine whether it was reasonable that their amount received be reduced, what their interests were, and the defendants have to give proper consideration to whether it's appropriate to settle the proceedings, compromising particular beneficiaries' interests. Another issue which can arise is the interest of beneficiaries who are under a legal incapacity. Commonly, that's beneficiaries who are minors. A minor is a person under the age of 18 years. Under the Minors Property and Contracts Act, a minor is presumed to be bound by a contract that's for their benefit, and the minor understands what they're doing at the time. Where there is a minor, often a tutor should be appointed to protect their interests. In some states, the approval of a minor's contract can be done by the court or by the New South Wales, by the public trustee in other jurisdictions other than New South Wales. Where a tutor isn't appointed and a minor beneficiary's interest is compromised, often the court will appoint a solicitor to consider the compromise that the minor is making and whether in all the circumstances it's in their interest to make that compromise. Often where there's going to be costly legal proceedings and the claimants is likely to get an order from the court. Often in those circumstances, a legal practitioner can indicate to the court that it is in fact in the minor's interests to have their entitlement reduced in order to prevent any further costs coming out of the estate where the order was likely to occur if the matter went to a hearing in any event. Often with a resolution of family provision proceedings, there's going to be tax or other duty considerations. Where those matters can be anticipated, it's a good idea to get that tax advice prior to the mediation so that the parties can be informed of their position and the impact that the resolution will have on their rights and particularly any tax implication that will arise. It's often not possible to obtain that tax advice for every eventuality, and so sometimes it's necessary to come to an agreement subject to tax advice being obtained. There can be stamp duty implications where one beneficiary who hasn't brought a family provision claim is getting a transfer of property. There can be capital gains tax implications in terms of whether the main residence exemption applies, where the property hasn't been sold within 2 years, whether the safe harbour exemptions can be implemented, where there is a payment coming from a private company, whether there'll be whether that will be deemed a dividend and the tax implications of that, land tax on property, and whether there can be some safe harbour exemptions relied on, and any income tax which may be relevant for the beneficiary in terms of perhaps a trust distribution from the testamentary trust. Okay, so a binding agreement has been entered into. What are the next steps? So other than the deed, what other documents are required? Is there going to be PEXA transactions required? if there are there going to be any other documents that need to be prepared? And if so, what documents are they, and who's going to prepare and who needs to execute them? It's important to set out what's expected of the parties following the resolution, and what obligations that they have to bring the agreement into fruition. Where there's going to be an ongoing trust, there's some particular matters that have to be taken into account. So, for instance, if a claimant is given a crisp order or a portable life interest over particular real estate, questions such as who will be responsible for the maintenance and upkeep of the property while that person is in residence. Does there need to be a fund be set aside from the estate in order to meet those expenses, or is the life tenant going to be responsible? Does the remainder beneficiary have the right to register a caveat on the property while there is a crisp order? And the crisp order would usually envisage subsequent properties, and do those rights to lodge a caveat apply to subsequent purchases as well? If the initial property is sold and another purchased and there's a surplus between the sale price and purchase price, what's going to happen with that surplus? Who's entitled to interest that's earned on the surplus if that remains in the estate? Where a refundable accommodation bond is going to be purchased for the life tenant, where usually that refund will go to the estate of the resident. So if that's intended to go back into the estate for other beneficiaries, consideration has to be given about whether there's an acknowledgement that that amount is held on trust. Often a trust is better than saying that the estate will be, that it will be a liability on the estate, because of course in those circumstances it will be in line with the other liabilities that have to be paid out of the estate. So a trust wouldn't be subject to liabilities, or indeed if the estate didn't have any other assets to meet liabilities. And moving on to drafting warranties and indemnities. So generally when used in a contract, a covenant is a promise to either do or refrain from doing something in particular. Covenants are also understood to be made under seal, meaning that in order for a covenant to be enforceable, it has to be contained in a deed that's signed, sealed and delivered. Whereas a warranty is generally defined as a contractually binding promise within a contract. In the context of family provision proceedings, it's usually representations made by the parties, being statements or acknowledgements of certain facts. There may be warranties about the plaintiff's financial or material circumstances, or the nature and value of the estate. An indemnity is often sought on behalf of the executors of the estate, particularly where they're not otherwise interested in or receive any benefit from the estate. So where there's an executor who doesn't have any personal interest in the estate, an indemnity may be important in order to protect that executor, where to protect them from any further claims where the estate is being completely distributed as a result of the agreement between the parties. Also, in terms of indemnities, it's important to consider whether the indemnity is going to cover the cost of enforcing an indemnity where proceedings are necessary, and also where you're acting for the person who's giving the indemnity, you may want that to be capped only to the extent of the benefit that they receive from the estate, and not above that. Releases are quite common in family provision proceedings. Specific instructions are, of course, required where your client is giving a release. It's important to consider whether a release is given just on a particular topic and whether other matters are carved out. Also, releases have to be reasonably specific. In the case of Grant and John Grant, it was held that a general release may not be given full effect to. In that case, a general release, it was said that a general release will be construed so that it doesn't exceed the true purpose of the transaction. A legal personal representative is not automatically entitled to release from beneficiaries. If before distribution the executor or administrator wants a release, then beneficiaries are entitled to ask for the accounts so that they know what the position of the estate is before they provide a release. So in New South Wales, Section 95 of the Succession Act deals with releases. The release won't be binding unless it's been approved by the court, and the court will consider releases carefully because, of course, they can't be overturned unless there's been fraud. So the court, in determining approval of a release, is going to want to be satisfied that the person giving the release is of the view that the release is to their advantage, that it's prudent to give the release, that it's fair and reasonable to give the release, and that they've been given independent advice about their rights. In New South Wales, it's also possible to apply for an inter vivos release. That's handy in terms of where there's a property settlement following a divorce, and the parties want to ensure that there's complete separation and that their beneficiaries don't have to worry about a family provision claim after their death against their estate. It's also sometimes relevant where in blended families where a claim is made by a stepchild against their parents' estate, often the second spouse will want a release from the claimant in respect of their estate as well. The legal costs of proceedings are an important consideration when entering into a deed. Often there'll have been costs orders leading up to the prior to the mediation, and consideration has to be given as to whether they're to be vacated. It's often useful to have an agreement about what costs are going to be paid out of the estate, and if it's the plaintiff's costs, then the preferable aspect would be to either agree on a quantum or for it to be paid out of whatever the order that the plaintiff is getting, because the last thing you want is a further disagreement or proceedings about quantum of costs. Confidentiality clauses, I don't suppose that they're quite so common in family provision claims, particularly because once the court has made orders about the proceedings, it's public record, and any evidence that's formally read to support the making of those orders will also be a public record. Deeds will often contain boilerplate clauses. Often those are the clauses at the end of the deed that people don't pay much attention to, but it is important to have a look and see what those clauses are. Often there'll be a best endeavours clause. There'll be a clause that says the agreement binds the legal personal representative and the assignees of the parties, so that if one party dies, then their estate is bound. There's usually an entire agreement clause, a counterpart clause, so that deeds can be executed in many different parts, and then the one document will be considered as the clause. Jurisdiction clause, it's important to consider what jurisdiction will be invoked if there is need for litigation, and considerations are where are the parties? Usually it will be cheaper to have litigation in the jurisdiction where all of the parties are, and also where the assets are as well, because if you've got a judgment, you want to be able to enforce the judgment in that jurisdiction. And also it's often a boilerplate clause that the parties have obtained independent legal advice. One of the sort of boilerplate clauses in court orders is granting the parties liberty to apply. That's often useful if there's other aspects of the case which will need consideration by the court after the proceedings have been dealt with. Other jurisdictional issues, particularly with New South Wales, is if you were to commence, if there is notional estate and you're a plaintiff, then you may particularly want to commence in New South Wales. As an executor, you may particularly want to commence elsewhere. In respect of New South Wales and jurisdiction, Section 64 of the Succession Act provides that a family provision order can be made in respect of property that's situated outside New South Wales, only if the deceased person was at the time of death domiciled in New South Wales. Okay, so looking at some recent cases, the case of Daly and Donaldson is a New South Wales case, and that was that arose when the parties came to an agreement at mediation, but it was discovered later that the settlement was based on a misapprehension. The claim was brought by a son, and after the mediation, it was found that the son was adopted by his mother's de facto partner, which raised an issue as to whether he was eligible in light of the adoption to make a family provision claim. When the matter went before the court at first instance, the judge was asked to make the orders because there had been an agreement, but the court wasn't in a position to make the orders because there was no jurisdictional basis upon which to make the orders, given that there was no eligible person, and so a family provision order couldn't be made. That was taken on appeal. There was an appeal as to whether there was a binding agreement and whether orders should be given effect to, given that there had been an agreement. It was held that the decision at first instance was correct, that as the applicant wasn't a son, there was no basis for the making of the orders. The Court of Appeal stated that merely because the parties to proceedings come to an agreement to make for the court to make a family provision order, it doesn't entitle the parties to have that order made. The court's required to exercise its discretion, either to make the order the party is seeking or some other order, or to decline to make the orders. So it's important to bear in mind that even though an agreement has been made at mediation, the court doesn't rubber stamp the orders to give effect to that agreement, and it may be that the court declines to make the orders. And that was reiterated in the case of Wild and Majuri. In that case, that involved testamentary capacity and also family provision claims. At the hearing, orders were handed up for the court to make orders in terms of a family provision claim that was sought, and the court reiterated that it has to be satisfied that the orders were appropriate. And emphasise that the court had a discretion, and that if there's no jurisdiction to make the orders, then the court will have to decline to make them. In an ACT case of Richardson and Richardson, the judge in that case set out the considerations and the correct approach that has to be followed when considering family provision orders. First of all, there's the threshold questions that have to be addressed before an order can be made. Those threshold questions have to be met even where there's agreement between the parties. The fact of the agreement is significant, but it's not the be-all and end-all. Where there's been an agreement and the parties are represented, that's going to be relevant. And the significance of the agreement arises because the courts want to encourage resolution between parties, and that coming to a resolution, it means that the court doesn't have to consider a hearing, and that there's a range of outcomes that could be determined by a court, and so a resolution can fall within a range of outcomes. The court, further in Richardson, the court stated that that orders won't be made in order to satisfy an extraneous purpose, that the purpose of the legislation has to be adhered to, and where the court determines that the orders that are sought are for some other purpose, it's unlikely that the court will make those orders. In Ridgeburn and Lynham, another ACT case that dealt with a resolution where the court was asked to make orders, but where the beneficiary didn't consent to the making of the orders. In that case, the court emphasised the duty of the executor to inform the court of all of the relevant matters, and particularly a relevant matter is where a beneficiary hasn't consented to the proceedings. In this case, the court wasn't told that one of the beneficiaries didn't consent to the agreement, and the court was under a misapprehension that all of the beneficiaries agreed. In fact, one of the beneficiaries' interest was significantly impacted, and didn't consent to the agreement. In those circumstances, the court declined to make the orders. The parties went away and negotiated again, and were able to come to an agreement that accommodated the interests of the beneficiary. Last case that I wanted to look at was Durack and Latham. That was a judgment that was delivered last week in the New South Wales Supreme Court. That dealt with a family provision claim that had settled. Orders were made noting that one of the eligible persons was unlocatable. And then 10 weeks later, that unlocatable person filed a claim, and that was the decision in Durack and Latham. The claimant had made contact within a 12-month period of the date of death and in fact made contact on the day that the orders in the first proceedings were made, but the court wasn't notified of the contact. So the court made orders in the first set of proceedings, noting that one eligible person couldn't be contacted, but in fact that person had made contact on that day, and then brought proceedings which were resolved, and orders were sought to be made by the court. The Justice Meek was very unhappy that the court hadn't been told that there was contact made by that eligible person. He stated that really, for the efficiency of the court, all family provision claims should be dealt with at once. It's not the case that the court wants to have to deal with a succession of claims, one after the other. The comments that the judge made were, firstly, he required that the solicitor provide an affidavit to the court to explain how orders were made on the first occasion when there had been contact by the eligible person. He was satisfied with the explanation given by the solicitor, who said it was an unfortunate mistake, and he recognised that that mistakes are made, and that it was important to draw the court's attention to any error as soon as it was made apparent. He also made some comments about the duty of practitioners and also administrators and their obligations to the court to provide all relevant details where orders are being sought for resolution. He made some interesting comments about consent settlements and repeated the comments that we've seen in the previous cases about jurisdiction being necessary in order for consent orders to be made. In New South Wales, Justice Lindsay has often said that it's not consent orders, because it's really the court has the jurisdiction to make the orders, and all the parties can do is propose orders to the court. Where there is jurisdiction, the parties are legally represented, then there may be a lower threshold to convince the court to make the orders, but it's still not going to be a rubber stamp, and the court has to be satisfied that it's appropriate in all circumstances for the orders to be made. In exercising the jurisdiction, the court will have regard to the desires and considerations of the parties and their legal representatives. The sort of things that will be considered are the nature of the assets, the interests of the parties who are entitled under the will, and the legal advice that all the parties are legally represented and have the option to obtain advice. A court may reject a compromise reached by a party where the proposed sum for the applicant lies outside the possible range of outcomes, if it's being too high or too low, or where giving effect to a settlement may fail to effectuate specific policies of the legislation or amount to an abusive process or otherwise offend public policy in a demonstrable way. Justice Meek also refers to the ability for trustees to obtain judicial advice where there's doubt about a resolution, or where there's doubt about parties being able to consent to the settlement that's reached. An example that's given is the case of the application of Scarley. In that matter, there was an estate of approximately $16.5 million. The claim was brought by the widow. Under the will, she was given a form of an annuity, and there were some grandchildren who were the residuary beneficiaries. The widow and the 4 children came to an agreement that she'd get the whole of the estate and bear her own costs. Orders were sought about that, and the judge determined that because the executors obtained judicial advice because of the interests of the grandchildren, and the judge said that they were justified in continuing the proceedings because it wasn't appropriate for the applicant to receive the whole of the estate. Also, His Honour considered the situation where there are disputed settlements, and also referred to the extent to which negotiations could be referred to in trying to enforce a settlement. So this decision is very useful to read because it really clearly sets out the considerations that are necessary in resolving a family provision claim, and what the obligation of the parties are in order to have orders made. So in conclusion, the preparation of binding settlement documentation is an important part of any mediation process or the resolution of a dispute. It's clear that clear drafting of clauses will prevent further dispute over the terms of the agreement or whether there was ever an agreement reached. And in family provision disputes, there are additional important considerations to be borne in mind, such as whether the court is going to be in a position to make the orders that the parties seek. Thank you, Lisa. That is all of that I wanted to say. I'm just looking to see about any questions. There are no questions.
Thank you so much for that, Anthea. Just to our delegates, if you do have any questions, you can submit them via the Q&A button to ensure that they're answered. Feel free to type them through. I'll read the closing script and I'll have one last check before we close the session out. Thank you again, Anthea, for an excellent session today. And thank you everyone for participating in today's event. You'll be redirected to our online exit survey shortly. We ask you to please take a moment to complete the survey as your feedback is very important to us. We thank you in advance for your feedback. Wish you a pleasant afternoon and hope to see you at another event by Attend the Education Network soon. It doesn't look like if any further questions come through, Anthea, so I'll close the session there. Thanks again, everyone. See you next time.